Hi, welcome to the legal wing of Perchance to Read, where I read one word or legal term and quickly break it down for trial watchers. As I say each time, there's no focus on any one trial in this series, just the trial words. And as always, nothing in this video is intended to be legal advice to anyone about anything. Okay, let's jump right in. Imagine a world where anyone can be detained indefinitely without trial, without evidence, and without a chance to prove their innocence. Or imagine a completely fair trial with circumstantial evidence that swirls in just the right way to make an innocent person look guilty in an honest court of law in front of a well-intentioned jury or trier of fact. Habeas corpus can be powerful enough to overcome those bad odds. Habeas corpus, the great writ, the key to any unjust cell door when nothing else will open it, a piece of paper that has the power to set an innocent person free seemingly against all odds. When you think about it, habeas corpus both acknowledges that no criminal justice system is perfect and also aims to perfect a criminal justice system by returning to a locked up person who should otherwise be free their liberty. Habeas corpus is Latin for "you shall have the body." It literally means deliver the body, which is just a fancy way to say hand over the prisoner, let them out of jail. The practice of habeas corpus first appeared in the year 1215 through language in the Magna Carta that said, "No man shall be arrested or imprisoned except by the lawful judgment of his peers and by the law of the land." In other words, a jury of one's peers determining guilt or innocence based on legitimate laws on the books. Sound familiar? Habeas corpus came into existence as a vehicle to counterbalance the king's, quote, divine right to incarcerate people, end quote. By the 1600s, though, habeas corpus was used to free those also incarcerated by constables and other law enforcers. In fact, modern-day habeas corpus petitions are captioned as the defendant versus the warden, and not the defendant versus the state or federal government. So it's not the people versus Jones, or Jones versus the people. If Jones is incarcerated in a prison where Smith is the warden, Jones's habeas corpus petition would be captioned Jones versus Smith. Sometimes the prisoner will use the name of the Secretary of the Department of Corrections for the jurisdiction where the prisoner is incarcerated, but it's common to see the warden's name appear on the other side of the V in the caption. Sometimes a petitioner may also use "in Ray Jones on habeas corpus." Again, I mention this to emphasize that habeas corpus is about incarceration and a demand to set the body free if that body should be free. While habeas corpus ensures accountability and prevents the abuse of power by authorities, its real power is in the way it gives individuals the ability to initiate proceedings in a court of law to challenge the legality of their detention. That last point is crucial. Imagine if an unfairly incarcerated person had to wait for the authorities to discover their error and work to reverse it. That person could be waiting a long while or, well, forever. The extraordinary power of habeas corpus lies in the incarcerated individual's ability to initiate the process for reversing the error, to wave the flag from their prison cell and say to a court of law with the authority to do something, "Hey, I shouldn't be in here." That is extraordinary in both senses of the word. It's out of the ordinary, and it's also amazing in its empowering ability. Indeed, within the courts, a petition for a writ of habeas corpus is included in one of the types of petitions for extraordinary relief, because it's different from the ordinary process of an adversarial trial designed to lead to a verdict, but the words extraordinary relief also carry the other meaning, the one that says use of this relief can overcome an otherwise mountainous, even though fair, process. Arguably, the right to habeas corpus transcends traditional boundaries that might define or hem in rights that stem from politics, culture, or geography, and is viewed more as a broad human right that is endemic to human existence, enshrined in the constitutions of many countries as evidence of that belief. To be sure, habeas corpus is systemic in democratic societies, a guaranteed right that is taken for granted to be there if needed. But its universal application demonstrates the wide belief in the fundamental human right to liberty. From Australia to Zimbabwe, and many countries in between, there is a firm, inalienable right to habeas corpus. By the time the United States framed its constitution in the late 1700s, habeas corpus had deep roots in the notions of liberty. So much so that there isn't a provision in the Constitution that proactively, explicitly, grants the right to habeas corpus relief. Instead, Article 1, Section 9, Clause 2 of the U.S. Constitution states, "The privileges of writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it." In other words, the U.S. Constitution describes when habeas corpus can be suspended because the presumption is that habeas corpus is an ongoing privilege to be accessed when needed. It's already there. No need to add it to the Constitution. Of course, there is irony in this. The original U.S. Constitution left in place African slavery, which reveals that the framers, the men who crafted the Constitution, didn't necessarily have a good grasp of what liberty actually meant. They baked one man's ownership of other men into the foundation of the nation, ironically just one clause up from the clause on habeas corpus. Indeed, Article 1, Section 9, Clause 1 discusses the prohibition on the federal government limiting the importation of persons. Yeah, slavery. The very next clause, Clause 2, is the one that discusses when habeas corpus can be suspended. But their ability to grasp and take for granted the privilege of habeas corpus relief, considering their inhumane approach to slavery, almost proves the point that habeas corpus was so much a part of the fabric of freedom that even among men who were ignorant enough to continue on the course of slavery, and who owned slaves themselves in some cases, habeas corpus was something to clearly be included and addressed in the original Constitution. It was like, well, of course we have to have a section on habeas corpus because, well, it's a thing, even if only for some people. It was clearly too ubiquitous by that point to ignore, and all discussion of it is as a pre-existing concept. Since this video is about habeas corpus, I'll leave there the irony of slave owners who perpetrated genocide of indigenous peoples to found a nation on land that wasn't theirs, somehow acknowledging habeas corpus. But it's worth pointing out that the inexplicable juxtaposition exists to emphasize how prevalent habeas corpus must have been by the 1700s. On a different note, it's important to remember that habeas corpus relief is not designed to simply determine whether an individual is innocent and to reverse their conviction in a court of law if they are. Habeas corpus is about unfair incarceration and the overall conditions of confinement. In fact, if an innocent person who is no longer incarcerated or on parole or otherwise subject to the oversight of the Department of Corrections wishes to prove their innocence, habeas corpus will not be available to them because they are not incarcerated. Remember, habeas corpus means you shall have the body. But when there's no body to deliver, no incarcerated individual to free, no warden on the other side of the case caption, there's no relief to grant and no ability to file a habeas corpus petition. Instead, the person would need to use other legal processes to establish their innocence. Meanwhile, an admittedly guilty prisoner may nevertheless file a petition for a writ of habeas corpus to challenge their confinement on grounds of innocence. Yes, they can do that. Or on other grounds of unfair or inhumane confinement. For example, if they are being detained in a 5 feet by 5 feet, or for my international audience, 1.5 meters by 1.5 meters cell, wherein they can't stand or lie to full body length, or they are not permitted to bathe, or are deprived of regular meals or medical care. Perhaps they're scheduled by law to be released on a certain date and are nevertheless being detained beyond the term of imprisonment to which they were sentenced. Or they're being detained in a jail without charges being brought, arrested and put in a cell, and never arraigned or permitted to plead not guilty in a court of law before a neutral judicial officer, or to seek bail. Or maybe they've been transferred to another facility against their wishes. They could be facing unfair deportation. The warden in their prison could be withholding their mail. In other words, habeas corpus can be used to challenge any kind of custody or incarceration that is unfair or unlawful. As with other areas of the law, for example, Miranda versus Arizona, cementing the idea of Mirandizing arrestees, reading them their Miranda rights during police custody that includes interrogation, and saying out loud to them, quote, "You have the right to remain silent," etc., habeas corpus has a landmark case that changed the destiny of criminal defendants in the United States, as you'll see in a moment. Here's what happened. In 1961, One Clarence Earl Gideon was convicted in Florida of breaking and entering a pool hall and stealing some combination of money and drinks. He was sentenced to serve 5 years in prison. After his conviction, Gideon asserted in a habeas corpus petition filed first in Florida that his conviction was unconstitutional and that the Florida Department of Corrections secretary illegally incarcerated him because, at trial, Gideon had requested a defense attorney as an indigent defendant and had been denied counsel by the trial court. The trial court had decided that since Gideon was not on trial for a death penalty offense, he was not entitled to free counsel. Gideon went through the trial without an attorney and was forced to defend himself, and well, we know how that turned out. The Florida Supreme Court, however, denied Gideon's petition for a writ of habeas corpus. In 1962, with nothing to lose and still representing himself, Gideon handwrote a petition to the United States Supreme Court for a writ of certiorari seeking review of the Florida Supreme Court's denial of his petition for a writ of habeas corpus. These are photos of his actual petition. It was just 5 pages long. 5 pages heard around, well, the country, which changed the course of countless lives and still counting. Powerfully, Gideon asserted on page 4 of his petition that because he was, quote, compelled to make his own defense and, quote, incapable adequately of making his own defense, it meant that, quote, petitioner did not plead no contest, but that is what his trial amounted to, end quote. That's pretty raw. He's saying with simple, pencil-scratched language, by refusing to provide an attorney who could have mounted a competent defense, you basically forced me to plead guilty. That's actually a mic drop argument. Somehow, the handwriting and plain language make it all the more powerful for the human simplicity of it. According to page 2, Gideon did attach his earlier denied petition, but that attachment was an exhibit to the petition. The actual petition was just those 5 handwritten pages. Gideon also attached the Florida Supreme Court's brief denial order. No formal opinion had been issued by the Florida Supreme Court, which is common for a summary denial of a petition for extraordinary relief. It's easy to see how the plain petition, the earlier pleading of his case in his Florida petition, and the brief denial order may have grabbed the U.S. Supreme Court's attention for the sheer need for relief for a solitary man behind bars that the petition evoked with its simplistic characteristics. But one can also see how the court could have dismissed the petition as lacking substance. In a win for jurisprudence, in 1962, the U.S. Supreme Court granted Gideon's petition for review of his case, and by the time the court heard the case, a man named Louis Wainwright was the Florida Department of Corrections secretary, and thus was born the famous case of Gideon versus Wainwright. Remember, the caption on a habeas corpus case is the defendant versus the warden or other incarcerating authority. Wainwright had oversight of the corrections department in Florida that incarcerated Gideon, so the caption read, Gideon versus Wainwright, a case that left a massive footprint on American jurisprudence. In a prescient move that almost proved Gideon's case against Wainwright's incarceration of him, the U.S. Supreme Court appointed counsel for Gideon for what now amounted to his petition for habeas corpus relief in the U.S. Supreme Court, reviewing the trial court's failure to appoint counsel for Gideon during the original trial. Before the High Court, in addition to what Gideon noted about the de facto guilty plea, Gideon, in his initial handwritten petition, and later Gideon's appointed counsel, asserted that Gideon's conviction and therefore his incarceration were unconstitutional since the Sixth Amendment to the U.S. Constitution guarantees court-appointed free counsel in serious criminal cases if the defendant cannot afford counsel. The U.S. Supreme Court agreed with Gideon and overturned his conviction. He wasn't immediately freed, though. Instead, he won the right to a new trial. In his second trial, he was acquitted, meaning he was found not guilty and set free. The jury was out for just 1 hour of deliberations before finding Gideon not guilty. Beyond Gideon's freedom, the decision in Gideon versus Wainwright had lasting impact that continues to this day and that is embedded in habeas corpus and criminal defense jurisprudence throughout the United States. The immediate impact was that soon after the decision in Gideon versus Wainwright, 2,000 indigent defendants in Florida who had been denied counsel at trial were set free. The more wide-ranging impact was that the breadth and depth of the public defender system in America expanded drastically after Gideon versus Wainwright, for once the U.S. Supreme Court guaranteed counsel for any indigent criminal defendant facing serious charges, it necessitated a massive system for providing free counsel in every corner of America. Every jurisdiction has some version of a public defender system. Today, the notion that someone would be forced to go to trial facing serious criminal charges without an attorney representing them is unfathomable. It's actually laughable. Not in real life, not on TV would anybody believe it. We would say, "Where's the defendant's lawyer?" In fact, criminal defendants who wish to represent themselves have to establish to the court that they are up to the task. Otherwise, the court will require that they proceed with appointed counsel. So we've come full circle from Gideon begging for a lawyer to defendants having to fight to go it alone. Even those who represent themselves are often provided with a standby attorney to guide them in the courtroom. Representation by counsel of indigent criminal defendants is baked into American jurisprudence, and for that we can thank Gideon versus Wainwright and one compelling 5-page handwritten petition for a writ of habeas corpus filed by a man who wouldn't stand for or sit through 5 years in prison for a de facto guilty plea he hadn't actually entered. Habeas corpus, the great writ. The ability to initiate the process that sets one free if one is illegally incarcerated or otherwise facing unfair conditions of confinement. It bears repeating, nothing in this video is intended to be legal advice to anyone about anything. Thanks for watching.